Oh, yeah, that's right. All right, so you're Romeo Johnson. Then Mr. Johnson's cases are set for trial to begin with jury selection next Monday. Was the announcement?
We're ready, Your Honor. Secret trial judge provided um, trial court rules on issue. And that issue being we're going for the executive report on the opposition trial. Ellen, we evidence the next trial, no witness testimony. The evidence, one of the evidence one introduces a surveillance video that was introduced during the murder trial, what we call the sound not guilty. And that surveillance video shows what seems to be the sponsoring witness of that video will be out for a month. There's Rule 804 of the Texas Rules of Evidence, I believe, they can use the prior testimony of that sponsoring witness, so we would subject to examination. We have secured transcript from that witness's testimony. We provide a copy of it to the Mr. Wilkerson, and the court will allow us to use the transcript. There's no need for it. Your Honor, I'll be some prepared to argue that the first learning of unavailability unless Mr. Coleman told you something yesterday.
Not see anything. There was I guess, just recently filed a notice of intent to introduce transcribed testimony.
I did file with regard now against the pencil testimony as well. You fully probably understand.
Which Robert John was that? Remind me what I'm.
Romeo Johnson, never tried with these were the victims. One of the twin brothers, the Barnes, Barnes.
Yeah. Yeah.
It's real positive. Brother was in a wheelchair.
Give me just a second. Yeah, you're right.
Judge, I know you're reading the Judge Freeze. Help me let you know we're in a 2-day process.
No, take me just a second.
Yes, Your Honor.
I don't know that this would.
My interpretation.
I mean, under 5, so 804A5.
804. Yeah,
Well, first is A is the criteria for being unavailable. So a declarant is considered to be unavailable if. So you've got to get one of those 5 to be unavailable. Then you go to B. So it's not 1, 2, 3, or 4. So 5 would be the only one possibly. It states that is absent from the trial or hearing, and the statement's proponent has not been able by process or other reasonable means to procure the declarant's attendance or testimony.
That's what we're hanging our head on. My issue is that case is here. Can't found the effort.
Okay. And so, all right. So if we're going to get into that, we'll wait and do it at another time. I'll either lunch or like tomorrow morning or something.
Yes.
Because I need to set. This is probably. We're down to maybe 2 cases, so I will need to make that decision and number the cases. So let's do this, because I would need to hear that information. I think I want to look up a little case law just to make sure. So you've got one witness?
No witness at all.
No, one witness that's unavailable.
Yes.
And that witness would be sponsor.
It shows
And then
for same purposes, state court.
I just feel like without reading that, and I've never had this come up, where in his own trial, introducing testimony seems to violate. Well, I mean, it's almost like you're forcing him to testify by putting on prior. I don't know. Let me look into that.
Party. I mean, you don't stand under the.
I just need to do some research that if it's, I know if it's another party potentially, talks about when it's a criminal case, what's given as a witness at a trial or hearing of the current or a different proceeding and is now offered against the party.
You very well could be straight people, right? He did it not.
Okay, let me look into that. You look into that as well. So 804, it looks like we've got two things. One is under A with regard to the unavailable witness. The other is under B, which is the former testimony of your client. So let's, I'll give you an opportunity. About how long do you think you guys will be going?
We anticipate finishing this afternoon, Judge. Come back from the lunch break, or
No. You're in the middle of a trial. I don't want you to have to think about this and do that. I will number the cases tomorrow morning. So let's take care of this. Are you available to come? It won't take long. That gives me some time this afternoon to also do a little research.
I've got another case in the 317th, oddly enough, but I think you can kind of delay
if you
that.
can come here first.
Yes, Your
It won't take us longer than, it'll take 15 minutes. I mean, there's really, I'm assuming you're investigator, it will be quick testimony as to the unavailability. The other is just legal issues that we all need to just look at.
I'll ask for a trade out.
Perfect. All right. So head back down there. We'll get you back over here tomorrow morning, 9 o'clock.
All right. Thank
Okay.
you.
Sounds good. And if everybody gets here a little early, we can start early. I'll try to be here early as well. All right. Go back with the bailiff. We'll see you tomorrow. Yes, sir. You'll come back tomorrow, and that way we know what's going on for sure if you're going to trial or not. Yes, sir. Good morning. How are you?
Thank you.
Ma'am? All right, ma'am, you're Louisa Magruder. And Ms. Magruder is currently on probation for sexual assault of a child in cause number 1625158. Motion to revoke probation has been, or motion to revoke unadjudicated probation has been filed. And Mr. Bynum, give an announcement.
Yeah, we're ready. Yeah. Speaking with members.
Sure.
Myself and Lang, who are still not shotgun computers. She's actually one class cleaning. Still right.
The judge meticulously reviewed all counts, from failure to report to alcohol screenings. Each not true entry resets the case for sentencing, ensuring defendants face consequences fairly. Legal process is precise. Evidence, testimony, and pre-sentence reports all matter.
I know her. And but I agree with the criminal lawyer. I don't have much of a conflict of practice. So the lawyers in the case called me. What I see, they say about being on MHA that I'm the last party. Everyone in here. She's 18 station. Yeah, right in there.
Let me stop you. Because I guess just as far as kind of procedurally,
yeah.
If there is the way I'll handle all of the motion to revoke. So if there's an agreement y'all can get that taken care of, the paperwork for whatever's going to happen. If there's not an agreement and you want to argue for me to do certain things, then what I'd rather do is go through the motion, get pleas of true or not true, and then what I do is reset the case for sentencing hearing so everybody has time to provide whatever information they want, bring in witnesses they want. Probation will do an updated pre-sentence report that'll give me more information, and then I'll listen to all of that on that day. Okay?
Very interesting. Could I just add where I was going with that?
Uh-huh.
I was wondering if the court considered should TRAD a lot more
So what would happen is I would still get an updated report because I need to see what all if they agree to that, then yes, I will consider it. So if y'all have an agreed recommendation, yeah, cannot go because of I didn't think her underlying offense. She's not eligible.
Thank you so much. I want to.
No, please.
I'm for no.
Yeah. Okay.
We're not gonna read anything that we've done.
We've been here before. I feel it's unfortunate that I recognized Miss Magruder over the last few years, and so apparently I have. So okay, so all right. So here's what we need to do then, based on that, just so that we can all get caught up, is get the pleas of true or not true to the allegations, and then reset it for a hearing. You can provide whatever you need, argue whatever you want, bring whatever witnesses. State can do the same. We'll get that updated report, and then I'll make a decision. Okay? So let's do this then. Ms. Magruder, please raise your right hand the best you can, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? All right, thank you. You can put your hand down. And will your client waive the formal reading of the motion? So, Ms. Magruder, in cause number 1625158, I have a motion to revoke your unadjudicated probation. It shows that you were placed on probation January 29th of 2018 for sexual assault of a child, second-degree felony, and that was a 10-year deferred probation. Is that correct? And then it alleges that you violated your probation. Count 1 alleges that you failed to report as directed to the probation department on May 23rd of 2025 and to the administrative hearing on June 2nd of 2025. And is that true or not true? Count 2 alleges that you failed to work faithfully at suitable employment and provide verification of that. Is that true or not true? Count 3 alleges that you failed to submit to alcohol and/or drug screening on June 2nd, May 28th, and May 19th of 2025. Is that true or not true? Count 4 alleges that you're behind in your court-assessed fees as of June 2nd, 2025, in the amount of $8,645. Is that true or not true? And then count 5 alleges that you failed to enter and successfully complete the Jefferson County Drug Intervention Program, JCDI, and that's from the order from September 24th of 2024. Is that true or not true? All right, so I will have pleas of not true entered for all 5 counts. Again, we'll reset the case for sentencing, and I will ask for an updated pre-sentence report. Obviously, anything that you think is important for me to know, get that information to Mr. Vine, and he'll present it to me on your behalf on that date. All right, we'll see you back on that day. Thank you. Good morning. Are you Derek Green? And will your client waive the formal reading of the indictment?
Sure.
I think we're going on less, correct?
Yes, Sean.
I'm getting there, sorry. All right, Mr. Green, in cause number 25 DCCR 1119, the state has elected to proceed on count 1 only, and in that count, to the lesser included offense of a Class B misdemeanor terroristic threat from June 19th of 2025. And how do you plead to that charge? And are you pleading guilty freely and voluntarily? And because you did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Smith? Do you fully understand that? And
Sentencing hearings will follow with updated reports and evidence. Waiving rights or motions doesn't remove accountability. This is a clear look at how the justice system enforces compliance and protects the public.